Ashudevan, Chief Advisor, MediateGuru, to deliver the opening remarks and formally begin today's wonderful session. Over to you, ma'am.
I just want to check for audio. Am I audible?
Ma'am, you're not entirely audible. Could you?
Am I audible now? I need to be a bit louder, I believe. Am I audible now? Sorry, sir.
Yes, yes, ma'am.
Thank you. Thank you, Shori sir, and thank you all the participants for joining us. Thank you all the dignitaries to taking out time and staying with us. So good evening, everyone. I'm Dr. Ashu Devan. I'm the Chief Advisor of Mediate Guru and an Assistant Professor at Vivekananda Institute of Law. So it is an immense pleasure and privilege to welcome you all to this panel discussion on the repels of Gayatri Balaswamy and consequences for domestic and international arbitration in India. To our esteemed dignitaries, Honorable Mr. Justice Hemant Gupta, Honorable Mr. Justice Ajay Rastogi, Dr. Mukul Shastri, Mr. Chakrapani Mishra, Mr. Vaibhav Gagar, and Mr. Ankit Kumar.
Ma'am, there is some sort of issue with your voice. Can you please speak? Can you please check the mic?
Am I audible, Param, now? Am I audible?
Ma'am, you're audible, but the voice is a bit low.
A bit low. All right. So I need to be louder. So once again, I would like to thank all the esteemed dignitaries, Honorable Mr. Justice Hemant Gupta, Honorable Mr. Justice Ajay Rastogi, Dr. Mukul Shastri, Mr. Chakrapani Mishra, Mr. Vaibhav Gagar, and Mr. Ankit Kaur. Thank you for gracing us with your invaluable presence and expertise. Your insights are truly anticipated and will undoubtedly enrich this discussion. I also extend a warm welcome to all our distinguished participants who have joined us today from various corners, eager to delve into this significant topic. Your presence underscores the growing interest and importance of arbitration in our legal landscape. The name Gayatri Balaswamy resonates deeply within the arbitration community, signifying a landmark moment that has sent ripples across both domestic and international arbitration practices in India. This decision has brought to forefront critical questions regarding the interplay between national laws and international arbitration principles, the enforceability of awards, and the evolving jurisdiction of our courts in arbitration matters. In an increasingly globalized world where cross-border transactions are the norm, efficient and effective dispute resolution mechanisms are paramount. Arbitration, with its promise to speed, confidentiality, specialized expertise, has emerged as a preferred choice. However, the legal framework surrounding arbitration is constantly evolving, and landmark judgments like the one we are discussing today play a pivotal role in shaping this trajectory. So for all of you joining today, this session is not just an academic exercise, it's an opportunity to gain practical insights from the very best minds of the field. You will hear diverse perspectives on the challenges and opportunities presented by recent developments, understand their implications for your practice or business, and perhaps even contribute to the ongoing discourse through your questions. We aim for this discussion to be interactive, thought-provoking, and ultimately to equip you with a clearer understanding of the current landscape and future directions of the arbitration in India. Please feel free to utilize the chat box to pose your questions to our panelists. They are eager to engage with your queries. Without further ado, I invite you to join us as we embark on this enlightening journey. Thank you. Over to you, sir.
Thank you, ma'am, for those opening remarks. May I please invite Mr. Ankit Kumar to formally take this discussion forward?
Thank you, Shaurya and Dr. Ashu, for the introduction, and good evening, ladies and gentlemen. I'm delighted to welcome all of you all to today's session on arbitration post Gayatri Balaswamy, implications for institution, judiciary, and industry. We are fortunate to be joined by a distinguished panel of experts, honorable former judges of the Supreme Court, institutional leaders, senior advocates, law firm partners, and general counsel, each offering a unique lens on one of the most significant arbitration ruling in recent memory. The Supreme Court's decision in Gayatri Balaswamy marks a pivotal shift in Indian arbitration law. For the first time, the court interpreted Section 34 and 37 of the Arbitration and Conciliation Act to include an implied power of modification of arbitral awards, going beyond the traditional binary of setting aside or upholding an award. The 4:1 majority held that courts may intervene to correct manifest errors apparent on the face of the record while still claiming to uphold the principle of minimal judicial intervention. The ruling has triggered widespread discussion. Will it lead to enhanced judicial efficiency or increased litigation? Does it empower arbitral institutions to preempt judicial corrections or dilute the finality of award? How will it affect India's global standing under the New York Convention and the Uncitral Model Law? For today's session, we'll explore these questions in depth, unpacking the domestic and international implications of the judgment and response of institutions, the legislative gap, and the real world challenges for legal practitioners and businesses. Now, to begin with, it's my privilege to welcome Honorable Justice Hemant Gupta. Sir, the Honorable Supreme Court has affirmed that courts can now modify award for apparent errors. Although there is Section 33 of the Arbitration and Conciliation Act, which already provides mechanism for tribunals to correct or clarify their own awards. As the chairperson of Indian International Arbitration Center, and with your extensive judicial experiences, how do you foresee Gayatri Balsami judgment impacting the operational protocols and administrative efficiency of arbitration institutions in India, particularly concerning the review and finality of domestic awards?
So you're on mute.
You are mute, sir.
Yeah. Good evening, Ankit and other panelists and other participants. The judgment is, of course, a paradigm shift in the arbitration ecosystem, where the power of modification of the award has been upheld by the constitutional bench, which is rare because sometimes earlier there were 3 judge bench judgments, 2 judge bench judgments to say that it cannot be modified, but now the law has been settled. I don't think so it is anybody's case that the award, whatever may be, is final. There can be some errors, some illegalities. It needs to be corrected. To what extent and to what manner will remain the question to be examined. The award is sacrosanct. It should be accepted, but human failings are always there. Sometimes, there are 4 claims, 1 claim stands omitted, and it can be always mentioned. That is what the provision of Section 34 4 is, that the parties can ask the tribunal to decide this question, keeping the challenge under Section 34 pending. There is International Chamber of Commerce, Paris. There were 3 arbitrations which were decided by the tribunal, constituted by it or under, and the arbitration was conducted by it. All awards were set aside for the reason that is cut, copy, and paste. Even institutional arbitration like ICC could not detect the mistake of copying the material paragraphs from the earlier awards. So these kind of mistakes can happen, but obviously it should not happen. ICC, I am told, is very particular about the correction of the awards, arithmetical or clerical mistakes. Actually, they go to the merits of the controversy as well when they oversee the corrections of the award and its effect. ultimately in our country, it is a judgment law. The judges decide whether particular award should be set aside or not set aside, whether part of the award should be set aside or the entire award should be set aside. That is the hard fact of life. And if the court is conscious of, the court is satisfied that there is something illegal has been committed by the arbitrator, court will find way to undo the wrong. That way, I would say that the 1940 Act was a little more precise. Not precise, was simpler when challenging the award. Under Section 34, one clause says if it is contrary to a public policy. The second is it's against the fundamental policy of public law in India. All these phrases are sounding, but very difficult to define. What is public policy? What is the fundamental policy of Indian law? In one judgment, probably you are aware, in saw pipes, the court picked up the judgment under the 1940 Act and applied it to 1996. I belong to an era when 1940 Act was in force. I used to conduct cases under 1940 Act where the grounds of challenge of the award were very limited, but very, I think, comprehensive enough. I just read one of the paragraphs. Ground is that award has been improperly procured or is otherwise invalid. It says many things, and it without specifying on what grounds it can be set aside, because the grounds of challenge cannot be in a straitjacket formula that this ground would be there or not. If the conscience of the judge is satisfied that there is some illegality, the court will find out the way to set aside award or to upend award. That is the crux of the matter. It is judgment law. You have to satisfy the conscience of the court, and unless you satisfy that there is fairness in the award, you may not succeed. I remember the lawyers, Mr. Vaibhav and others would be aware of the fact. Section 100 of the Code of Civil Procedure talks about a second appeal on a substantial question of law. It's very difficult to define what is substantial question of law. So what satisfies the court becomes a substantial question of law. What doesn't satisfy the court is not a substantial question of law. Same way, the public policy, fundamental policy, or the patent illegality, they are all subjective. The test is subjective. It's a subjective test on the basis, and there can't be any objective criteria. Sometimes we say subjective opinion based on objective criteria, but we can't have any criteria A, B, C, D is satisfied, then the award will be satisfied. This is the problem. Or the liberty is given. Of course, I may not agree with the judgment because the court has actually interpreted Section 34(4) to say that the power of remand is there. That is not the power of remand. The remand means that you set aside the judgment on merits, giving, on ABC grounds. Even under Civil Code, Section Order 41, Rule 23 says that if you want to remand, you have to give reasons for setting aside of the award, of the judgment. But it's not a remand. It's something like seeking a report, and report also by the parties on the question which has not been probably decided, which may be a ground for setting aside of the award. Say there are 7 issues which were raised before the tribunal. issues have been dealt with. One issue has not been dealt with. That issue may lead to setting aside of the award. The provision of Section 34(4) gives that liberty that if one issue has not been decided, you can possibly go to the tribunal again. You can't go to the tribunal again on the questions which have been finally decided, because you have a time limit of 30 days to seek clarification in respect of if you require any clarification. But if there is no clarification sought within 30 days, then award is final. You can only seek intervention of the arbitral tribunal in respect of the issues which remain pending. So that's what I say, that it's legally speaking, I would have been happier if the award was not to be set aside. But since the constitutional bench has said it, so we have to honor it. The dissenting judgment is equally forceful, but that will be relevant if there is any further reference at a later point of time regarding the correctness of this judgment. As of now, the majority judgment, which will prevail. So with this, I will only say that the awards are subject matter of challenge. They can be challenged on good and valid ground. What is valid ground depends upon the fact each case. Another thing which was asked was, what is the role of institutions? I may share one very interesting experience. I'm heading an institution and we got an award running into 170 pages, but none of even one line is not clearly written. One word written and then there is few words missing, and the whatever words written, that also doesn't make any sense. Our staff struggled to correct it somewhat way or the other, but it was impossible. If that kind of an error happens, then what can be done? If in ad hoc arbitration, that award will be final and the court will be struggling, this award has to be set aside because nothing was clear. Because of the institutional arbitration, the institution is overseeing this kind of a mistake, that at least it makes sense. You may not interfere with the ultimate decision, but the award has to make sense. It should be clearly understandable. If it is not there, then what can be done? That's what I'd like to say there. Thank you.
Thank you so much, sir. Now we have Mr. Vaibhav Kakkar, Senior Advocate, Supreme Court of India, sir. Sir, litigants now have the possibility of modification of as a remedy, which earlier it was just setting aside of an award. Now they have a remedy for modification of an award. Now, as a counsel representing litigants, how does Gayatri Balsami's judgment practically alter the expectations and strategic choices of parties approaching the court for Section 34 challenges against domestic arbitral awards?
Thank you for the question, and thank you for having me on the panel. I will just borrow from what Justice Gupta said, and I couldn't agree more. In real life and practicality, the matter or whatever the issue is depends upon the judge who's hearing the matter. And if the judge finds fairness in not just the manner in which it has been arrived at, but also what the final outcome is. It's for the counsels to do the jugglery over there, whether it's public policy, whether it is a patent error. These are, as Sir said, very, very wide concepts. And on a daily basis, I mean, I can tell you without exception in Section 34s, the roster benches are overloaded with Section 34s, even though the Honorable Supreme Court has time and again come down to say it's got to be in a very narrow spectrum. And yet we see that even if the high courts are dealing with it, in a narrow spectrum, very often the Honorable Supreme Court may turn it around because it pinches their judicial conscience at time to let something pass, which ought not to have happened. And before I address your issue very directly, I'd like to highlight one point, and it doesn't make me very popular to say this, especially in the arbitration circles, but I really do believe that it's an important perspective. When we have the right of first appeal, which is a statutory right, versus a second appeal, which is on a pure question of law, as Sir had pointed out. So you've got an appellate mechanism where there is a judicial body in the first round and an appellate mechanism which is going to treat that on merits, on facts, as well as law. There's a check and balance there. We, for the right reasons, in order to make proceedings expeditious, in order to cut costs, etc., have reposed great amount of faith in the arbitration system, where we are saying that the arbitrator's view is final. Why? Because it's come out of the choice of the parties and an arbitrator has been appointed. Unfortunately, the way I look at it, a huge number of awards really suffer from basic errors, whether they are legal errors, whether they are factual errors. And because of the narrow spectrum and the constant, rap on the knuckles by the Supreme Court, which is saying that it's got to be narrowed down as much as possible, the legislative intent being clear about it, the various stakeholders saying there should not be too much appeal, etc. And rightly, again, these are two facets to this. But my worry has always been that there is very little judicial review of 90% of cases which have a problem, according to me. The first round of arbitral awards, and all the awards are also not by the most trained judicial minds. Please remember that. They're very often, on law, they appear to be rather mediocre. So you have no mechanism because you're going to have to fit it into the spectrum of patent illegality very often. Now, when we go into court in a 34, you have good days and bad days as counsels, and as they say, client ki kismat. But you will have the judges either stretching the concept of patent illegality or stretching the concept of public policy when they find that even on merits, factually on merits, and I'm not saying error apparent on the face of record, but on merits, they find that this doesn't seem really right. There's, this ought not to have been done that way. So there'll often be a pushback by the judge to the appellant to say, but, and I see this often, but Mr. Gagar, is it falling within that scope? And you are going to, try and spin a yarn and say it really does fit into that little pigeonhole. And if it's a good day, it'll go through. If it's not a good day, then, it may not go through. So there is no fixed yardstick. And I'm very grateful to Justice Gupta for pointing that out, because it's a practical reality which is not said often enough or recognized often enough in public platforms, but it is at a huge level of discretion, which is already inbuilt into any statute, including the arbitration. In that background, now, if you look at this judgment, what has this judgment really done? It has said 4 or 5 things. It has said, one, if there's an error apparent, you could look at it. If there is arithmetical clarificatory issues, look into it. If it's severable, there's one part which is manifestly illegal, the other part which can sustain itself on law, divide it. If you need to remand it back to a limited extent, you can. And I agree with Justice Gupta on the Section 100, on the concept of a remand. I'm not too sure it really does fall within 34.4. I think also purely academically speaking, it is a bit of a stretch what has been done here. And then they have gone into the interest quotient to say pending light and post-award, the interest could be dealt with. I actually believe that it is somewhere positive for the jurisprudential growth. And Justice Vishwanathan, again, I have the greatest respect, even as a counsel when he was there, one of the most brilliant minds I've always felt, and a very strong judgment, dissent judgment. But I think if you look at it practically, what is the Supreme Court saying? It is saying that let us not have another round of litigation, because if you've got to set aside an order for something which is correctable, then correct it. Don't set aside the entire award and get everyone back to square one, right? I mean, I can tell you, some of the co-panelists here, Mr. Mishra and Mr. Shastri, are dealing with some of the largest arbitrations probably in the country and internationally, because infrastructure arbitrations are massive stakes. And having done a few road NHAI-oriented arbitrations, and Mr. Shastri is leading one of them, the stakes are so high and the time is short. If you're going to keep revolving within the system of saying, oh, there was an arithmetical error which ought to have been clarified but cannot be clarified, now you're going to be remanded back. And now you're going to have an award set aside just on that. Or if there are two parts to the award, one is sustainable, one is actually severable, but sorry, you cannot do anything. There cannot be any modification at all. I can tell you that it's damaging. If you have such a rigid formula for everything, it's damaging very often. So I think this flexibility is coming with the right intent, the right thought, and it's a step in the right direction. Having said that, there are red flags. And the red flags are, very clearly, it's for the ingenuity of the councils very often to find a way to stretch the meaning. And the meaning will be stretched. And you need one precedent to interpret this subsequently now, which is going to expand the scope of appeals. And suddenly, under the guise of a modification for an error apparent or for some errors or which could be dealt with, you may have courts looking into it as a first appellate court as well. Because again, it's at the judge's discretion to interpret the words of this judgment. And the words of a judgment are not as strict as the words of a statute. The intent has to be looked at. And I can look at I can imagine many situations where, depending on which side of the fence one is arguing on, there is a lot of interpretative play in this. So just to summarize and conclude to the question, I believe it's a positive step. I believe there's a lot of play in the joints, however, as councils. I think the arbitration community, more or less has taken this positively. And this is subject to the experts on the panel, because I'm more a litigator in courts than, before the tribunals on a daily basis. But my feedback has been in the few arbitrations that I'm doing that there is a positive, outlook to this. I think internationally there has been a bit of an outcry, because this kind of comes into the zone of where are we with the New York Convention, where are we with the various other conventions on the executability of this. I thought Article 142 of the Constitution being referred here, a little discussion there. But again, Article 142 of the Constitution, as Justice Gupta, maybe another question would come Sir's way on this one. 142 really is the widest amplitude, isn't it? And once the Supreme Court decides to do something, it's stronger than statute, frankly. But the high courts don't have that discretion, and 142 would not get invoked on a daily basis. It really would be in exceptional circumstances. So I think positive, but a lot of play in the joints for interpretative ingenuity. Thank you.
Totally agree with you, Mr. Rizal. There are terms like manifest errors and errors apparent on the face of it that has not been exhaustively explained or interpreted in this particular judgment. So there has to be interpretation. The council has to bring it out and interpret.
The councils are licking their lips on this, I can tell you.
Definitely, sir, definitely. Now we have Mr. Chakrapani Mishra. Hello, Mishra, sir. It's an honor to have you in the panel, sir. Sir, the judgment theoretically draws a clear distinction, clear line between correcting manifesting errors and conducting a full merit review. So, in your experience, how challenging will it be for legal practitioners to effectively argue and for courts to delineate this fine line of practice, especially when dealing with complex commercial disputes where errors might be intervening with the substantial findings.
Good evening again, everyone, and it's a privilege to be a part of this esteemed panel. And before me, Justice Gupta very nicely summarized the entire landscape. And Senior Counsel Mr. Gaggar has already answered this in part. So, regarding what is going to happen in courts, I would like to take a step back and express myself in three buckets. So, the bucket one, where I talk about as a pure student of law, the judgment will have its own share of criticism because in pure academic terms, section 34 does not permit any kind of modification. That's my view. So that is more of a purist concept where one can think of that if you don't read into a particular section to find something. Court has gone at length in trying to read that and come up with that, incorporate that concept of that the bigger takes the minor inside and so on and so forth. So that is as far as academic bucket is concerned. The main heart of the court has been always to strengthen the process and try not to multiply the litigation. So the heart of this judgment is in the right place. At the same time, as I said, when viewed from academic point of view, it is something that raises questions. Now, coming to the third part is where your question lies, and that is where is going to be a completely bloodbath, according to me. The way I look at it, that this is and where I'm coming from, I'm totally talking about based on personal experience. It's in the wisdom of Supreme Court. It's a very fine, one of the finest minds sitting there, our apex court. They have very finely defined the guardrails, as was argued before the court that there should be guardrails. If we are reading modification of an award, then there should be proper guardrails. Guardrails have been defined. But then with that judgment, apex court's judgment is law. Now, if that is going to be litigated across the country, it opens the door so wide for opening up the entire award for an appellate review. And that is where the problem is. That is where it's like, as Senior Counsel Mr. Gaggar said, that we are all smacking our lips, seeing that all awards are going to be opened up one way or the other. Because party A will say that no, this award has to be like, there is no room for this is absolutely fine, etc., etc. Party will say the B will say that it finds squarely in this, it needs to be modified because otherwise it will not stand. Then there comes the second question when we are talking about whether the issue that can be separated is totally dehors or totally separate from the other parts of the award, or it is not. Again, there will be dispute on that whether it is separable, it is not separable, or it is intermingled. Because Supreme Court says that if it is intermingled, then it should not be modified. So these are the problems that we are going to face in real life, and that is my concern. Thank you.
Thank you so much, sir. We also have Dr. Mukul Sastry, General Counsel, Cube Highways. Sir, considering the increased judicial intervention post Gayatri Balasamy, how would you advise as a General Counsel a corporate board to recalibrate its risk appetite around arbitration as a preferred mechanism for high-value long-term contracts?
Thank you, Ankit. Thanks, MediateGuru for having me. A very interesting discussion on legal points led by Justice Gupta and then Mr. Gaggar and Mr. Mishra. So we have heard the litigant perspective or the litigation perspective, how judges and senior counsels and lawyers they look into it. From industry perspective, if I may say, so what an industry wants or what a litigant wants from a dispute solution system. So I guess there are three things ultimately which anyone is looking. One is it has to be efficient, it has to be predictable, and it has to be expeditious. When I say efficient, it means the person who is handling, who is the judge or the arbitrator. That person understands the nuances of law. That person understands the nuances of the industry or the dispute. So this person is well versed with the legal as well as the technical aspects of things. When I say predictable, it means it doesn't matter whether it goes to Mr. A or Mr. B or Mr. C. Whosoever individual is the arbitrator or the judge, ultimately the principles of law are laid down well. There is a predictive certainty that, okay, in this case, this is what, more or less, this is where you will land up with. And third is expeditious. It has to be done in reasonable time. You cannot just wait for ages for some outcome. Now, on these three touchstones, if I see that what will be the impact on arbitration per se of this judgment of Supreme Court. Now, interestingly, in arbitration, especially what the industry thinks that in India, the judicial intervention is too much. Whereas the basic purpose of arbitration, which even the court has said in para 16 of their judgment, that the basic purpose is, or para 40, 41, and 49 also, that the basic purpose is that ultimately it is the party autonomy or the parties who have chosen an arbitrator, and then that arbitrator is deciding something. So parties have to be given that kind of freedom. Okay, you've chosen someone, and this person has decided something on you. Now, in appellate stages, unlike in a court process where you have not chosen your judge, so there is an appeal at first stage of appeal where the appellate court is a maker checker, and then there's a second appeal on questions of law. Here, since you have chosen your own judge, better you, whatever merits of the case is, you have to be satisfied with that, and only in appellate court on a very limited grounds you can challenge it if the person was partial or some other things. So that was the basic fundamental of arbitration, especially the 1996 central model. Now, in this judgment, and I totally agree with what Mr. Gaggar said, totally echo what he said, that once it goes to the court and you find that in section 34, if the court does not have the power to even modify a little bit, if there's a small computational error or small manifest error, which the court, if that power is not there, then ultimately you see it is going to harm the interest of the parties and of the arbitration, because you are back to square one then. The court will set aside it and you're back there, and on the smallest of the issue, you are again litigating. Or likewise, if there's something severable, you have to again come back and you are doing you are reinventing the wheel. So therefore, this kind of power, and I totally agree with what Justice Gupta also said, it may not be legally tenable. Maybe if you are purely as a question of law, you see your principles of law, and like Mr. Mishra also said, as a student of law, maybe there can be some issues. But from a practical perspective, from an industry perspective, it's a welcome step. That is, that power has been given under 34. But we have a different issues in India. If you see, most of the section 34 is with district judges, with the lower judiciary, where the appreciation of nuances of corporate matters may not be that heavy as they understand criminal law or civil law per se. So there's a possibility that under 34, they just go ahead and either overdo things, they go into the merits, because the Gayatri Barasami judgment says you can do and modify the award, whether it is for computational reasons or clerical reasons or for manifest error, but it has a condition that it should not be such which necessitates any merit evaluation. So you have to ensure that there is no merit evaluation you are doing at section 34. So it has to be so apparent on the face, that error, that you can, without any merit evaluation, you can do that. Now, what can be for this or what cannot be without merit evaluation, and again a very, very subjective question. And then, as I said, section 34 generally goes to district judiciary at times, lower judiciary, and then it goes to high court. So you can see there's a lot of the appellate rights that parties now have. So first they can go and exhaust 34 with lower judiciary, then 37 at high court. They have modification. That modification can also be challenged before an appellate court under 37. Now, whether that is possible, not possible, again, there can be disputes. So what this judgment has done, though the intent was very right, intent was to ensure that it is in favor of the litigant, but somehow because of these questions now, a lot of open ends are there. And you have to see that how it pans out in the next year or couple of years, to see that how we really see that the section 34 modification is only done for the right reasons. So that is one fear which I would like to highlight in this judgment.
Right. So do you think that it will add an additional layer of litigation to the entire process of arbitration then?
It can be. So therefore, now the judges have to be really very cautious into what they are getting into, because now they have a good power, and with great power comes great responsibility. So it is for them now to really use this power in the right manner for the interest of arbitration, the interest of parties, so that India can really become an arbitration hub. So that is what I guess is now the ball is with the judiciary or the judicial officers, to ensure that this power is used very effectively.
Right. If I can come back to Honorable Justice Gupta again.
Yes.
Sir, the judgment diverges from the ancestral model law and international practices, and there are explicit concerns about the enforceability of the modified award under the New York Convention. So the dissenting opinion and various commentators have raised significant concerns about the Gayatri Balasamy judgment alignment with the international arbitration norms and its potential impact on the enforceability of Indian awards abroad under the New York Convention. From the perspective of IIEC, how does this ruling affect India's standing and effectiveness as a seat of international arbitration, and what steps, if any, can institution take to mitigate these concerns?
You are right that this judgment is not very arbitration ecosystem friendly. But if you go a little deeper, the clause E of section 48 is the award has to satisfy the law of the country in which it is to be enforced. So that will take into consideration the patent the grounds of challenge of the award. You can modify. In the beginning, I said that I would welcome there should not be modification. But the fact remains, if there is a judgment, we are all bound to comply with that. There is the entire thread of the judgment is that if we don't give power of segregation or modification, then it will lead to a second round, which will be again time consuming. And the idea seems to be that to cut short the litigation, to cut short the second round of litigation, we should give this power of modification. This is again, as Mr. Weber has said, that it depends upon the lawyers, that what kind of argument is raised. Judgment will be pressed by both parties to whatever extent that is helpful to them. They will write to interpret a particular clause in a manner which is favorable to them. But as far as I won't say that international community, there is any marginal, a major shift in respect of enforcement of the awards, international awards in India, because 48E, in fact, gave power to the court of the host country, where the award is to be executed, to go by the domestic law. The domestic law, again, gives power to the court to set aside award. And, set aside award is as the argument has been noticed, that the larger portion will include the smaller one. So if the main award can be set aside, the line of reasoning is that the smaller part can also be set aside. But as I said earlier, Section 5 of the Act says that there has to be minimum judicial intervention. And somehow or the other, we are introducing judicial intervention at the setting aside of the award stage, which we should have been slow in interfering with that. I will only say so. Thank you.
Thank you, sir. Now, Mr. Gaggar, you have mentioned about Article 142, so I'll come back to you on that particular topic. So, considering the Supreme Court's emphasis on doing complete justice through Article 142, how can litigants and their advocates best navigate the implications of these broad constitutional powers in the context of international commercial arbitrations?
Article 142 question should have been for sir, for Justice Gupta. He has been there, done that. I have never played out a 142 or never had the opportunity. That's on a lighter note. Article 142, again, what are we saying here? It is the power of the Supreme Court to do substantial justice. They have put it in a contour of 142. Even if you look at the high courts, there is no 142, obviously, for the high courts. But I'm sure my co-panelists here would agree with me that the judges would find a way if they want to correct a wrong which to them seems to be a wrong. It is interpretative play at the end of the day. 142 is a whip which is available with the Honorable Supreme Court. They do not have to go into trying to, create a chain or a story to try and justify it, right? But every day, I can tell you that the courts, when they want to bring about a solution which is right for them, are finding novel ways of interpretation and getting down to the same effect as a 142 does very often. And then the appeal will go to the Honorable Supreme Court. The Supreme Court may turn around and say, sorry, Mr. High Court, you had no power to do something like this. But I'm telling you, at a practical level, that happens very, very often. Now, 142 in terms of the interplay with international arbitrations, if you look at it, that's where the potential conflict of the New York Convention comes into play, right? I'm presuming that's what you're referring to over here. The New York Convention, the way the judgment has dealt with it is that they have not found any conflict with the New York Convention. They've said that 48E is equivalent to their Section 5 or Schedule 5 of the New York Convention. And as far as executability of any awards within India are concerned, the Honorable Supreme Court's verdict is going to be, the end-all, be-all of that. So there's not going to be a controversy there. The issue that you're going to find is when you're looking at enforcing awards overseas or Indian awards overseas, that's where this potential conflict could come into play. But also, please recognize this, that as far as a number of other countries are concerned, and subject to correction, I think, including England, modification of awards is permissible. Now, if that be the case, and if this Supreme Court judgment is placed when you're looking at that executability issue overseas as well, to say that this is something when you're looking at a modification, it is not as if you're doing away with the judgment. The doctrine of merger is going to be applicable. New York Convention talks about it being settled between the parties. I mean, it being enforceable, it being, I think there's a specific term that they have used over there to say that it is realized between the parties and they accept the award. If that be the, if I'm not mistaken, there's a particular word, right? If that be the case, then a doctrine of merger would be applicable. Doctrine of merger means that the award now, as modified by the I keep saying High Court, sorry, by the appellate court in the 34, it subsumes the arbitral award within that. And then it is the appellate court's award or order which is going to be executed. So I do foresee there being pushback. I do foresee there being a few more years of litigation on this particular aspect. But my immediate thought is that I don't think that there is a serious violation or a conflict with the New York Convention in this matter. But then it's going to be the judges of the other countries who are going to be looking at it. It's not going to be the judges of our country, right? They are going to be looking at the execution, and one would have to look at the precedents of those countries wherever the execution is going to be enforced. So yeah, I think this one is going to be a little tricky though. This one is execution is for foreign awards is going to be tricky overseas.
Does that add a layer of complexity of cross-border litigation strategies?
Absolutely. And again, if Mr. Shastri and Mr. Mishra, why I keep coming back to them is because they're dealing with cross-border disputes, and one is heading a client side, the other is, advising a client side with a lot of cross-borders. And I think it's going to be a major headache, and they're going to have law firms all over the world, wherever. See, the moment it's cross-border, it is no longer about just your country, right? So please imagine, and the cross-border, it also doesn't necessarily have to be just two countries. So please imagine there's India, UK, and US, and there is a dispute which spans these three jurisdictions. No law firm is going to be able to say, I am going to advise you on all the three jurisdictions. So you're going to have different teams from different countries who are going to be advising on it. And there is going to be hours and hours of deliberation on something like this, according to me. And there is going to be never a right answer till the matters are decided by the individual jurisdictions.
Right, sir.
Okay, just one word about 142.
Yes, sir.
No, 142 was always in existence. It could have, it could be easily omitted in the order because 142 could be exercised at any point of time.
Right.
It doesn't talk about the period. Without
Right.
the judgment, also 142 was available. Another painful, I would say, invocation of 142 in multiple manners. I would, one particular case I will talk about is the but Tamil Nadu government, where they say the
Yes.
governor can't withhold the power and other thing. There the president has been directed. Those directions are under 142.
Yes.
And 142, I remember as a judge in the High Court, I said in one of the cases, 142 is not a precedent. Because 142 is in the peculiar facts of the case. It doesn't let, but that's how the judgment has been given. So it is given.
Right.
So the line between judicial activism and judicial excessivism at times starts getting blurred very quickly.
Yeah, we forget about that there is a distinction between 141, 142.
That's so true.
142 is not meant for this kind of, where there is something glaring happening.
Absolutely.
You interfere.
Totally
to
agree.
do this substantial justice in that particular case.
Very
You
true.
don't lay down guidelines for the.
Very true, sir.
Totally agree with you, sir.
Thank you. That's all I wanted to say.
Thank you so much, sir. If I can come back to Mishra, sir. Mr. Mishra, the dissenting view warned that allowing modification could undermine India's credibility in the international arbitration community. How are the international clients and foreign law firms reacting to Gayatri Balasan?
I was hoping, Ankit, you will not ask me this question because neither do I have the stature of Justice Gupta nor the court craft of Mr. Gaggar. So my answer is going to be little sharp in that sense. Because as far as this judgment is concerned, with greatest respect, when it comes to international community, it is creating havoc. It's giving a very bad impression to our arbitration regime. We always have been criticized right from the public policy 2005 judgment, the Sukanya judgment, etc., where in name of public policy, we opened up everything for judicial challenge. We have always been known internationally as a jurisdiction of one step forward, two step backwards when it comes to arbitrations. Now, it's, as I said earlier, that heart of the judgment is in the right place. But arbitration, especially now we are talking about international arbitrations, it's a global thing. We are only looking inwards. We are looking at only at our country, but things have changed so much since we liberalized our economy because our corporates have gone out. We have contracts and agreements running into multi layers and multi jurisdictions. And what international community looks at is some kind of certainty. Now, when it comes to modification of award as a concept, it's not alien. It's inbuilt in the Act of UK. It is built in the Act of the US. It is built in the Singapore Act. They have taken a slight deviation from the model law, and they have built in this power within their act. So that gives a certainty to the community, to everybody, that yes, it's a possibility that court will look at it and court can modify. I'm not getting into the guardrails or judicial precedent there. So that is built in. Here in our act, one way or the other, it is not built in. And I think Justice Vishwanathan, when he was giving that dissenting judgment, he was talking about that only. That it's not, it has to be built in the act to give people certainty. And that's where international community is once again uncertain that what is going to happen to an award, if it is India seated award or if it's an award which has gone through the process, it is still is not final. I'll give you another problem to dwell with. If an award has to be enforced outside, it has to have attained finality. Now, whether after the award being rendered and it has reached all the way to Supreme Court and there is a modification, will that be the finality of the award? And then the concept of that subsuming of the court order into the award. It cannot be subsumed. And that will have to be tested by the other jurisdictions to bring in. Otherwise, it will be very easy to resist an award in other jurisdictions on these grounds, that it has not attained finality or it has not been subsumed. So those are the issues that we are going to face on practical side. Conceptually, international community is little hesitant on this part where we talk about certainty or making India a global hub. These things are a deterrent, in my view. Thank you.
So, sir, when India is moving ahead to becoming an international arbitration hub, do you think it's going to be a hurdle, this particular judgment?
See, it's not about judgment. It's not about judgment. Is fine. As I said earlier, it's about that uncertainty that we keep bringing about as a community, as practitioner community, and I'm talking about all stakeholders, judiciary, lawyers, clients, everybody who are stakeholders here. There has to be some maturity, some certainty that we bring to the table, and these things create some ripple which go a long way.
Right.
I don't have a better answer than that. I'm just sharing my practical apprehension and my discussion with various legal practitioners across the world.
Thank you so much. Now, if I may come back to Dr. Shastri. So, in the light of Gayatri Balasamy, what specific diligence or enhanced risk assessment measures will corporate legal department now undertake when negotiating international contracts that might be subject to Indian arbitration law, particularly concerning the potential for an award to be modified by Indian courts?
Sure. So right. So like we are a Singapore-based company, whereby we are investing into infrastructure sector in India. Now we acquire a lot of assets from Indian players, and in most of our contracts, you'll see that we have a CX clause that our arbitration generally go and prefer a CX arbitration. Now, the two reasons primarily for that. Number one is it gives us a bit of a certainty because CX, as I said, we look into for three things: efficiency, predictability, and speed. Generally, CX awards have been quicker, faster, and fairly predictable that, okay, if this is what the grounds are, this is where we'll end up. But then again, whenever in boardroom, ultimately it is always against Indian parties. So the enforcement has to be in India. And therefore, the Indian judicial intervention cannot be ruled out. There definitely will be there. So the idea is that, okay, the first in the first trial, it has to be a Singaporean arbitration tribunal, and maybe only in the appellate stage, if 34 somebody is challenging, then that also is not possible because seat is in Singapore. So generally, you have to go to Singapore courts for challenge. And then only for enforcement of that arbitral award, you come back to India and enforce it in India. So the intervention becomes lesser. And this is what the thought process are of most of the foreign players who are investing into India. But then when we see that Indian talent and Indian industry, I find the time now has absolutely right where we make India an arbitration hub. Indian centers, they really do really well. Because the kind of talent that we have, well, in Singapore also, ultimately we end up in Indian lawyers only. Most of the persons who go and defend us there are Indian lawyers. So ultimately, it's Indian talent only, which generally a company uses. So why not use the same talent in India? It is most cost efficient, it's more effective and efficient. So therefore, I feel in boardroom these discussions happen, and this judgment, like Gayatri Balasamy, somehow as I said, the heart, as Mr. Mishra also said, the heart is in the right place. The intent was right of the judgment. It has to be for the benefit of the party so that you don't have to reinvent the wheel again for even smaller things. So at least the intention is right. But now the time has come that judiciary itself has to now rethink that how are they going to ensure that what are the first principles to be set for the interventions in arbitration. On one hand, we need good arbitrators, someone who are more savvy. Now, in arbitration space, we are seeing, in addition to great judicial minds, we also have great lawyers and somebody from industry also coming in. So obviously, that talent pool now in India is growing, and that is what we should really leverage. But then, as you're asking about what kind of discussion we take in boardroom and such things, the discussion is that still India has to do a lot for this. Like, for example, as Mr. Mishra was saying that in Singapore also, this inherent this power is there for modification. So earlier in the Singapore Act, it was not there, but it was amended later. But then
Right.
again, what they have done is they have given timeline also for all these things. If you want to go for a computational error cycle, there are 30 days, and you can go and approach a party and approach, and they will decide it on this within this timeline, and the grounds are well laid. So therefore, maybe in India also right now, since every single thing in Indian arbitration is purely from judicial decisions, maybe we have to collate all these decisions and go for a final amendment and bring over all these things as part of the act so that it becomes more predictable and more certain. I guess right now, the need is, although obviously Indian Arbitration Act also has been amended quite a number of times in past, 3-4 times it has been amended. But somehow, again, can't agree with Mr. Mishra more that we have taken 1 step forward and 2 steps backward. So maybe the time is now ripe enough that we amend it in the act itself and bring all these points together and ensure that the judicial intervention is minimal and it's only for bringing out complete justice.
Right. Thank you so much, sir. Now I'll come back to Mr. Mishra once more. Just a small clarification, sir. So in your first question, you talked about guardrails and strict boundaries. This is for the viewers, it might be repetitive, but it is for a better understanding. So in your view, will these guardrails outlined in Gayatri Balasamy be sufficient to prevent an expansion of judicial intervention beyond the intended limited scope?
Good question. And again, the answer is what Justice Gupta has already said, that the framework has been set. Everything is right there. It is the other part, the actual practical part that plays out. Guardrails will ultimately prevail, but for them to prevail, to start from grassroots, it will delay and it will take its own time before it reaches the final shores of the Supreme Court, and Supreme Court says whether the X decision is within guardrails or not. So eventually guardrails will remain, but to reach there and to enforce them, it will take time. It will go through the entire process of the challenge on 34 and so on and so forth. Hope that clarifies.
Yes, thank you so much, sir. So thank you to each and every distinguished panelist for your insightful contribution. Now we may take some questions from the participants. So we have one question that has come from Anurag Chaudhary. What are the practical limitations now imposed on Indian courts when it comes to modifying or correcting arbitral award? In what ways will the judgment impact the confidence of domestic parties in choosing arbitration as a mode of dispute resolution? Justice Hemant Gupta, if we can answer this, sir.
No, the guidelines have been laid down in para from para 39, 38 to 40, 46, that there has to be error apparent on record, there has to be severability of the invalid part of the award. It should not be intermingled with the other parts of award. But, having said so, the practical implication of the judgment will be, as pointed out, will be gone into by the district judge in most of the cases or by the high courts. So it becomes subject matter of interpretation, whether there is severability, whether there is error apparent on record. Like review, it says that error apparent on record, but review is filed even on questions of fact. So these are the issues which will always arise. It will increase the burden of the court, which may further delay the finality to the arbitration proceedings. But I think that is the rule of the game. We can't help it.
Thank you, sir. There is one more question. It's given the absence of explicit statutory backing and the potential challenges this poses for international enforcement under the New York Convention. how do you envision balancing India's aspiration to be a credible global arbitration hub with the need of legislative clarity and consistency? Mr. Gagar?
Thank you. Again, I don't think this judgment is, it's a relevant judgment. It's an important judgment, but this is not going to define the course of whether we're going to become an international hub for arbitrations or not. This would have some merit or some, out of 100, you may put a couple of points on this. The fact that this is not backed by statutory, provisions. Again, even though both Mr. Mishra and Mr. Shastri said that that's what the international global players expect, because that gives them a little bit of certainty in terms of what the system is going to look like. But we have always, and like England as well, for that matter, we have always gone in judge-made law very often, and I do not expect us to change our DNA overnight in order to be able to kind of cater to what may look and seem right. Again, let me not be heard to say that it should not require statutory backing. Let me not be heard to say that this judgment is going to help us becoming a hub. But I don't think this is the major stumbling block. I think there are bigger issues. Justice Gupta pointed out 3 judgments which came about where there was cut, copy, paste of awards. Those are issues which go to the root of a problem. The independence, the perception of the independence of the arbitrators, of the institutions, those are important factors to be looked into. The efficiency of the system, cost is not such a problem in India. The efficiency of the system, something that the 3 fundamentals that Mr. Shastri has been referring to. We have to get into those aspects. And one fundamental thing, India is still not, I litigate and I arbitrate, and I'm also an arbitrator. But globally, subject to correction, that doesn't happen, right? You will have arbitration specialists. I mean, today, when I'm supposed to go and do a hearing or a cross-examination during the court hours for an arbitration, I'll request the honorable arbitrator to say, could we please have it after so and such time? And they very gracefully agree to it more often than not, because they understand that it's the litigators who are playing the arbitration mold right now, right? Until that eventually also changes, that arbitration by itself becomes a total specialized vertical where you do not allow the litigators. And I hate that day when it will come. But, once that happens, that's where it's becoming a really specialized model. The internal appellate mechanisms that have to be built in, there are talks about it. There are institutional arbitrations which have inbuilt that. All of those need to become real and not just on paper. And I can imagine arbitration to actually speed through, especially with the advent of AI, with everything now being recorded. You could transcribe it. They have the flexibility in the joints that the court and the judicial system does not, right? Because that's in the private space versus it being in the governmental space, and you've got to go back to the government for almost anything and everything. So there's a lot that needs to be done. I believe now there are a lot of very good brains who are at it. The industry is promoting it. And as Mr. Shastri said, I think we're on the anvil of being able to turn this around. And, it's the big conglomerates and the big law firms, really. It's not going to be the judges and the counsels who have to say, we want to do this in India. And once that whisper starts and becomes a loud noise, these kind of judgments are not what are going to push back the advent of India becoming an arbitration hub. Let's keep the focus on what are the problems plaguing it. Let's be real and honest about it and fill those gaps. And you have a massive opportunity here. Thank you.
Definitely, sir. So thank you once again to each and every distinguished panelist for your insightful contribution. The Gayatri Balsami ruling has undoubtedly stirred foundational questions about finality, efficiency, and India's positioning in the global arbitration arena. It is clear from today's session that the judgment opens new opportunities for correctness and fairness. It also brings new risks and challenges that will need to be carefully navigated by the stakeholders. With this, I give the floor to Kanika for the vote of thanks. Kanika?
Yes, sir. And with that, the insightful final point, we have unfortunately reached the end of our scheduled time for today's panel discussion. The ripples of Gayatri Balswamy, consequences for domestic and international arbitration in India. It was a truly illuminating session, and it has been. On behalf of Mediate Guru and everybody else who joined us today, I'd like to extend my sincere gratitude. Firstly, a huge thank you to our brilliant moderator, Mr. Ankit Kunwar sir. You have masterfully guided the conversation, ensuring we have explored the topic's many facets with depth and clarity. Thank you for keeping us engaged and on track. Our deepest appreciation goes to our esteemed panelists, Honorable Justice Hemant Gupta, Senior Advocate Vaibhav Kakkar sir, Mr. Chakrapani sir, and Mr. Mukul Shastri sir. Thank you all for generously sharing your valuable time and expertise and candid insights drawn from your diverse experiences. Your perspective on the domestic and international arbitration in India has been incredibly enlightening. Also, I would like to thank the ADR cell of DNLU Jabalpur. We hope this discussion has provided a practical takeaway and sparked further thoughts on how arbitration can be more effectively integrated with organization. A very special thank you to you, our audience. Your presence, engagement, and thoughtful questions added immense value to this session. Thank you for being such an active part of the conversation. Of course, this event wouldn't have been possible without the dedication and